Okay, what I want to do now is start exploring what we mean when we're talking about privacy laws. There is no right to privacy in Australia, and this is not the case in the US and in Europe. So, a lot of our popular culture and a lot of the language that we use is termed or expressed in terms of rights, but it is not the case in Australia that there is an inherent right to have information kept private. So, privacy protection in Australia is a patchwork of federal and state legislation, some common law principles, and of course the regulatory frameworks, the APPs. And I'll probably deal with the APPs in a separate video. So, Australia's constitution doesn't explicitly mention any right to privacy, and the High Court of Australia has recognised certain implied rights. So, for example, the implied right to make a political communication, but it hasn't recognised an implied right to privacy as such. The lack of constitutional guaranteed right means that privacy protections are largely dependent on statutory laws and common law developments. I'm going to talk about legislation in the next few slides, and actually I'll also mention the key case in the common law in the next few slides. But before I get there, I just want to talk about some recent developments and issues. So clearly in this context, we're interested in digital technology. And so while clearly the span of digital technologies that are impacted by privacy laws is much broader than AI, big data, and blockchain. The fact that we have big data in there means that we're looking at a broad range of uses of data and technology. I think it's also when we're thinking about digital privacy, we're thinking about data breaches, but we might also be thinking about online surveillance and the way that social media privacy has become increasingly significant, not the least because it's the technologies that we're interested that sit behind and drive those social media algorithms. Amendments to the Privacy Act over recent time, and here I'm talking about the Federal Privacy Act, have been aimed at addressing some of these concerns. So, mandatory data breach notification scheme was introduced in 2018, and there's some significant focus on that in the Canvas activities, in particular, looking at breach notifications and what it is that business needs to do and think about there. Secondly, review and reform is always on the agenda. The Australian government has been periodically reviewing privacy laws to ensure that they keep pace with technological and societal changes. There's been a lot of news in recent time, and we've spoken about it most likely in class, but definitely in these lecture series, about the times that the different government departments have come up against weaknesses or inefficiencies in the law and how that gets turned into a policy matter. Recent things include the Safety Commissioner looking at what our privacy laws, how they address children's protection and finding them wanting. The Attorney General's Department conducted a comprehensive review of the Privacy Act fairly recently, making recommendations for strengthening some privacy protections. And clearly, public awareness and advocacy is at the front foot at the moment. Organisations like the Australian Privacy Foundation are advocating for stronger privacy protections and greater public awareness of privacy rights, as well as technology literacy. That means that people understand that it's no longer just the issue of I've got nothing to hide, I don't care, but the ways that our personal information can be used might be things that they haven't expected before that could cause great harm. There's an ongoing debate about the adequacy of the Australian laws and whether Australia should adopt a more comprehensive approach to privacy protection, akin to what the EU does with the GDPR. While the GDPR is considerably stronger in the ways that it protects personal information and protects privacy, Clearly, if we go back to Lessig and theory, if we go back to these kind of competing approaches to thinking about how we regulate these things, there is a strong argument that though that significant amount of regulatory oversight and the red tape that comes with it makes producing technologies, makes interacting with customers where you need personal information more expensive, and the higher risks and higher costs are a disincentive to innovation. And so once again, we're coming back to those theories that we've spoken about over the last couple of weeks and thinking about, well, what does that mean? When do we actually need a right to privacy? And if we do, what does that actually look like? For my money, Australia does, it's clear, doesn't have a constitutionally enshrined right to privacy, but it does have a complex framework of laws and regulations that protect personal information. The absence of a single overarching right to privacy means that protections can and have been found to be inconsistent. They're reliant on legislative and judicial developments. And this means that it's a constantly changing an environment. I don't know what it would take to get a right to privacy enshrined in our constitution, but I don't know. What do you think? I mentioned before the common law. As I mentioned before, there are a number of cases where there have been hints at what a right to privacy might look like, but the High Court has always stopped short of finding that there is a constitutional right to privacy as such, or that there is an inherent common law right to privacy. The key case here is Australian Broadcasting Corporation and the Lena Game Meats. It goes back to 2001. Interesting case, actually. Lena Game Meats operated a possum meat processing business. Can't get more Australian than that, can you? Um, Animal Liberation in Tasmania surreptitiously gained access to Lena's premises and installed some hidden cameras to capture footage of the possum slaughtering process. Ugh. The footage was subsequently provided to the Australian Broadcasting Commission, the ABC, and the ABC intended to broadcast it on television. Lena sought an injunction to prevent the ABC from airing the footage. So for the business students, an injunction is basically a court order that stops a party from doing something. So it effectively creates a legal basis where a person has to stop doing something that they plan to do. So it was a significant judgment. Ultimately, the question of the injunction went all the way to the High Court, and it addressed a number of different legal issues. Now, some of these related to the conduct of entering the premises, some of them related to rights in relation to the broadcast. I'm just going to focus on the privacy and common law elements, but if you're interested, when you look at the slides, there's a link there that will take you to the whole decision. In relation to privacy and common law, there are two key points. The court considered that the broader issue of whether there is a tort of invasion of privacy in Australian law. So that became one of the legal issues that was considered. And we talked about torts in an earlier week. So you understand that a tort is a common law it's a beast of the common law, and essentially it's a civil wrong. So the question became, is it unlawful? Is it a civil wrong to invade somebody's privacy? So the majority didn't definitively establish that such a tort was there. And so ultimately it leaves the question open to the possibility of an Australian common law right. To the extent that it was discussed, and Justice Gleeson's judgment is the most important one here, he suggested that certain types of information might attract privacy protection, particularly when publication would be highly offensive to a reasonable person. In this particular case, they didn't find that that test was met. So ultimately, we've got this kind of opening of the door the possibility that this tort might exist, but given that it wasn't actually satisfied, the criteria for it wasn't satisfied, we don't actually have a definitive statement. Another thing that's interesting in the case was the court's consideration of the public interest. And there it recognised the importance of public interest in matters of animal welfare and transparency regarding commercial practices. So the court noted that the footage could contribute to public debate on these issues in relation to the slaughtering of animals, and that was a relevant consideration in balancing privacy and freedom of the press. Again, these things might come into play when we now look 25, close to 25 years on at the question of whether or not the way that personal information is being used and being manipulated, could that manipulation be something akin to a tort of invasion of privacy? So this is a landmark case in relation to privacy law. It highlights the complexities of privacy protection in the absence of a clearly defined tort of privacy, and it underscores the need for a cause of action to obtain an injunction against publication of private information. If you're interested in this, Stuart Stuckey, I think is how you say it, and Williams, there's a 2013 book on media law that's a Thomson Reuters publication, and well worth a look in relation to these questions. So, in relation to legislation, it's important to notice that, to be clear, that there is both federal and state legislation. So the primary legislation governing privacy at the federal level is the Privacy Act 1988. That's the legislation that regulates the handling of personal information by the federal government or federal government agencies, private sector organisations that have an annual turnover exceeding $3 million, and certain small businesses. Now, it's really important to notice that. So basically, the Privacy Act focuses initially or primarily on how personal information is going to be dealt with when a government department gets hold of it. And then it also extends many of those obligations to private businesses or non-government business, but only if they fall into certain categories, where categories of business collect very personal information like medical information, or when their turnover is greater than $3 million. Now, this I find really quite interesting. You look online at small businesses that are selling everything from, clothing through to, like bespoke clothing perhaps, or coaching services, or religious organisations, for example, that may well be collecting a hell of a lot of data, but because their business turnover is less than $3 million a year, they've actually got no obligations in relation to that. This is one of the reasons, and I'll come back to it most likely in a separate video when I look at privacy policies. One of the reasons why privacy policies are important, because they provide a contractual basis under which entities that haven't opted into the privacy law or aren't covered by the privacy law will have made a contractual promise to keep your information private. So key aspects of the Privacy Act include the Australian Privacy Principles, the APPs. I'll make a separate video and go through each of those. But in a nutshell, these are the principles that set out the standards, rights and obligations in relation to handling, holding, accessing and correcting personal information. Also, key regulator here is the Office of the Australian Information Commissioner, OAC. So OAIC. This is an independent agency which oversees the administration of the Privacy Act and handles complaints against breaches of privacy. There are also state and territory legislation. So in addition to the Federal Privacy Act, each state and territory has its own privacy laws and regulations. They govern what happens in relation to their government bodies. So they cover public sector bodies and often cover health service providers within their jurisdictions. So, for example, in Victoria, we have the Information Privacy Act 2000, we don't. It's been replaced by the Privacy and Data Protection Act of 2014. In New South Wales, there's the Privacy and Personal Information Protection Act, 1998, and Queensland has an Information Privacy Act, 2009. We also have additional federal legislation, which deals with email and marketing and telemarketing. So the Spam Act and the Do Not Call Register Act, the one that I reckon is being breached the most often, if you can tell by the number of phone calls that I get from unknown numbers wanting to tell me basically scary things. But anyway, on that note, so the legislation comes from a range of different things. Oh, one thing, sorry, more on my slide. I'm talking to my notes instead of my slide. Worth actually also paying attention to the surveillance legislation. So surveillance and privacy are not necessarily the same thing. So legislation that relates to surveillance governs video surveillance, geographical tracking, data and computer surveillance, listening devices, and incorporates within it the idea of workplace surveillance in some jurisdiction. And when we get to looking at employment laws, we'll come back to surveillance in some good measure. So I think that's enough for this particular video. In the next one, I'm going to talk about some privacy law fundamentals and go on to discuss what personal information is. In the meantime, questions, concerns, frustrations, or of course compliments, suggestions, you know how to find me.